Good day, everyone. My name is Melindi Dean, and I'm a legal advisor in Pretoria for the Consumer Protection and POPI department.
Good day, my name is Melinda van der Merwe, and I'm also a legal advisor in the Consumer Protection and POPI department.
So with regard to our current circumstances, 2020, we've all become accustomed to, the new norm with regard to COVID-19 restrictions. This has affected us in various ways. For example, some of us might have had to cancel or postpone our weddings or an exciting holiday that we're really looking forward to, or an overseas trip. Some of us also might be reasonably wondering, should I still pay my commercial rent even though I'm not getting a service for it, or should I still pay my child's school fees?
Yes, Melindi, we are certainly experiencing uncertain times. So today we are talking about the Consumer Protection Act and cancellations and the uncertainty of COVID-19.
Yes, so for example, a lot of strain has been put on businesses and consumers. For example, we don't know how to deal with cancellations. Do normal regulations and law apply to bookings that we haven't been able to commit to? So the relevant section that we'll be discussing today would be Section 17 of the Consumer Protection Act, and this discusses the right of consumers to cancel an advance reservation or booking.
Melindi, further in Section 17, they make provision for cancellation fees on that reservation. Melindi, can you please explain to us the reasonable grounds for a reasonable cancellation fee?
So Section 17.4 does discuss this. It discusses, is the cancellation fee that a company is imposing too high, or is it even reasonable that they are imposing a cancellation fee? So the Act does address 4 factors to consider if a cancellation is fair or reasonable. The first one being the nature of the goods or services that were to be provided. The second one would be the length of time or notice that the consumer gave to the supplier that they are cancelling a booking or reservation, because it's common practice or knowledge that a consumer should notify a supplier within a reasonable amount of time that they are going to be unable to commit to that booking. The third factor would be the opportunity for the supplier acting diligently to find an alternative consumer to go into the place of the consumer that cancelled. And unfortunately, with the uncertain times that we're facing, a lot of industries, currently still aren't able to open and to operate. So it is highly unlikely that they will be able to find another alternative consumer. Then the last factor that one does consider is the nature of the relevant industry.
So Melindi, we can see it's evident that COVID-19 has put an enormous strain on consumers and suppliers and put a spotlight on cancellation. In the latest newsletter of a CGSO dated January and March, they put the spotlight on both parties to be reasonable in this time. For consumers, they should accept vouchers and postponements from suppliers, and if a consumer can't accept a voucher or a postponement, the supplier should refund them in full. Reasonable cancellation fees applies when a consumer cancels voluntarily and where circumstances are unrelated to illness, death, or the lockdown.
Yes, that's 100% right. So in today's time, the consumer and the supplier will both have to act reasonably in terms of their cancellation, because as we know, it is neither the supplier nor the consumer's fault at present with regards to why the supplier couldn't commit or render services, or the consumer couldn't, accept those services or goods provided.
Exactly. And the other big question that was also in the spotlight this few weeks was school fees. Are parents obligated to pay school fees if their child can't go back to school, and even if you have to pay rent for a facility you can't use at this stage?
Yes, that is a very tough question. I can understand why a lot of people are having frustrations with that. So with regard to rent, this is a contractual duty on businesses. So the first step would be to fall back on your lease agreement. So a force majeure clause will entitle businesses to withhold rent in the event that this is an act of God that renders the performance impossible. However, unfortunately, a lot of commercial rent agreements do not make provision for the suspension of an agreement due to an act of God. So therefore, the businesses will have to approach their landlords in order to contractually lessen the rental burden that they have.
And just lastly, going back to school fees, parents are encouraged to pay their school fees wherever they can, and the schools are also encouraged to provide alternative measures to provide education to the children. Even if you can't pay your school fees, the first step you should take is go to the school and maybe make an arrangement to pay the school fees at a later stage when the COVID-19 has passed.
Yeah, so in conclusion, like we said, both suppliers and consumers will have to act reasonably in these difficult times that we are experiencing. You know, these are uncharted waters, and a lot of us are unsure of, you know, what to do in certain circumstances because these aren't your normal everyday circumstances. So in conclusion, should you need any more advice or professional legal advice with regards to anything relating to the Consumer Protection Act or the POPI Act, please SMS the word SEESA to 45776, or alternatively follow our link for more information. Thank you so much for listening. Have a great day.